Today, we are here on behalf of Canada's doctors to convey one overarching message. The CMA recommends that parliamentarians support the enactment of Bill C14 as proposed and without amendment. And before turning the floor over to my colleague, Dr. Blackmer, who will review CMA's response on the core elements of the legislation, I will provide our response on the overall approach. Put simply, the CMA strongly supports the government's overall response to the Carter decision. This includes legislative and non-legislative measures.
We also support the objective to support the provision of a full range of options for end-of-life care and to respect always the personal convictions of healthcare providers. To this end, we encourage the federal government to very rapidly advance its commitment to develop a pan-Canadian end-of-life coordinating system. Ideally, this should be in place by June the 6th. The CMA is aware that one jurisdiction has made such a system available to support connecting patients who qualify for assisted dying with willing providers. Until this system is available across the country, there may be a disparity of support for patients and practitioners from province to province. Finally, it is our position that Bill C14, to the extent constitutionally possible, must respect the personal convictions of healthcare providers by protecting their rights of those who do not wish to participate in assisted dying or to directly refer a patient to someone who does wish to participate. We would be very pleased to speak further on this critical issue, one that is also essential for a consistent pan-Canadian framework.
I'd like to begin my questions, direct them towards the CMA, just for clarification. Wasn't sure how many doctors you say that you represent, but you had indicated that you like the bill and you'd like to see it adopted without amendments. Is that correct?
That is correct. We represent over 83,000 physicians in Canada.
Okay. You know, I just find that really interesting because I haven't talked to one doctor yet that would hold to that position outside of listening to it here. So not sure where these doctors are that you represent. But
perhaps, if I may, we've consulted with tens of thousands of physicians over the past 2 to 3 years in the course of various national town halls that we've conducted across the country. We've done extensive polling and we've had numerous debates at our national annual meeting.
Okay,
so we do represent those physicians.
My initial questions I'd like to direct to the CMA. There's concern about conscience rights, and we've heard that from a number of groups, but are there any other procedures that you know about, apart from medical assistance in dying, in which there is a concern that doctors are forced to or coerced to perform a procedure, a medical procedure, against their will?
I would say probably the best analogy is therapeutic abortion. This is one where the medical profession has certainly struggled collectively and individually, and there's often a question around conscience rights and the right to objection, and whether or not physicians may have an obligation to refer to another practitioner there. So that's probably the closest analogous situation.
But physicians aren't required to conduct a therapeutic abortion?
No, that's correct. There's no requirement for them to do that, and there is only one province that currently has a requirement that they refer to a colleague, which is Ontario. Ontario is actually the only jurisdiction in the entire world with that requirement.
And do the colleges across the country, the colleges of physicians of the various provinces, they fiercely safeguard the conscience rights of physicians through their own professional regulations?
That's correct, and I would say that particularly on the point of assistance in dying, we've seen the 9 provinces outside of Quebec come forward with regulations. All of them, save Ontario, have wording that very clearly protects the conscience rights of physicians. But we have certainly seen some discrepancies in terms of the exact wording, and as I say, Ontario is an outlier in terms of their regulations in that regard.
And perhaps you can speak for a moment about the importance of self-regulation in terms of your membership.
Thank you. The self-regulation is very much a privilege and not a right of the medical profession, and it's something that we constantly must strive to uphold through our actions, collectively and individually again. And as you know, there are members of the public now on these regulatory bodies, and we look to them for guidance as well. This is critical to what it means to be a medical professional, the ability to self-regulate and to hold our members to a high standard. And so on issues such as conscientious objection, we do often look towards the colleges for guidance. This has been a difficult issue, again, because of some of the inconsistencies in the guidance that has come forward.
This is for the Canadian Medical Association, either one of the representatives. I'd like to know if you have any concerns with respect to Bill C14 and whether patients will have access or have difficulty accessing medical assistance in dying as it moves forward.
It's a very important question, and I would point out that when we've done surveys of the membership in the CMA, somewhere around 30% or so of physicians have said that if this becomes legal, they would be willing to participate. That may sound, on the face of it, low. It's actually not. That equates to tens of thousands of physicians. In Oregon, it's less than 0.6% of physicians who participate in assisted dying. So in terms of just the numbers, access won't be a problem. The problem is connecting patients who qualify with willing practitioners. And you can imagine that most physicians aren't willing to put their name out there to advertise that they're going to be participating in this. There are security and safety concerns. So what we need and what the CMA has been calling for is a system to help connect patients who qualify for assisted dying with practitioners who are willing to provide this service. At the same time, this means that physicians who don't want to participate or don't want to refer can have their conscience rights protected. So it's a way to satisfy both situations.
System, how would that system look like?
So there's actually a system in Alberta at the current point in time that the Alberta government has been working on where physicians can register with the central registry and say, I'm willing to participate, and patients or a healthcare provider can call that number and find out more information about the legislation and about the service, but also be connected where appropriate with a willing provider. And they put that in place because of the situation that they had where a patient in Calgary was not able to find a willing provider and had to travel outside of the province, even though there were many physicians in Calgary who could have assisted. So we desperately need this type of a system to make sure that we connect patients and providers.
I just also echo the comments, and I can honestly say the most common question I get from my colleagues who know that I've been involved at this level are asking me, do you know who's going to provide the service? So they may be willing to refer, but they, at this point in time, have no idea. And as Dr. Blackmer pointed out, it's unlikely we're going to have a directory or a list published somewhere. So this concept of a central referral coordinating system would be essential when June 6th arrives, that physicians would know there's a system, that patients would know there is a system, there would be no confusion, and that it will pave the way for access for the people who really should be accessing the service.